Yes.
Good morning, my Lords. My Lords, I appear for the appellants with Mr. Luckhurst, and on the other side are Sir James Eady, Mr. Roy Phillips, King's Counsel, and Miss Wolfe, Mr. Shepherd, and Mr. Laird. Housekeeping. There were two different bundles of authorities filed, and that's just because there's two bundles of authorities, but they were refiled because the sidelining on the first filed set was not correct. So there's nothing majorly different between them, and I'm not going to try and establish now which set you've got, but that's the reason why a new set of authorities appeared at some stage. There's two documents in front of you which I'd like to ask you to put at the back of the authorities bundle, please, if you have them in hard copy. It's the explanatory notes to the Act and an additional authority, both of which have been provided to my learned friend. In terms of how I propose,
I'm going to keep them separate because it's already rather full. Right.
In terms of how I propose to proceed, I propose to make some introductory comments by way of overview, then show you the key provisions of the National Security and Investments Act, then set out the principles under Article 1 of the first protocol, and then address the grounds of appeal and the errors in the judgment below.
Thank you.
This is an appeal from the order of Mrs. Justice Farbey, 4th of December 2024. The judge dismissed a judicial review challenge to a final order made by the respondent under the National Security Investments Act, issued on the 19th of December 2022. The final order required the first appellant to divest, that is sell, its entire shareholding in the interested party, UP. UP was at that time a small start-up fibre broadband provider to a handful of market towns in East Anglia. The reason for requiring the divestment was not because of anything that the appellants had done wrong, but because the Secretary of State considered that there was a risk that their ultimate shareholders, ultimate beneficial owners, might in the future come under the influence of the Russian state. And through their ultimate ownership of the appellants and the appellants' ownership of UP, the Russian state might come to exert what the defendant's officials described as owner influence over UP, which would be contrary to national security. The risk to national security therefore arose from the acquisition of UP by the appellants. But it is important to emphasise that the respondent did not suggest that the appellants or UP, or indeed their ultimate owners, were at the time acting in a manner contrary to national security. The risk related to a future possible event, namely the exertion of influence over the ultimate beneficial owners by the Russian state. The justification for the final order and the fairness of the final order were challenged before the judge below. The challenge was dismissed. The single issue before this court is whether Mrs. Justice Farbey was correct to hold that Article 1 of the first protocol of the European Convention on Human Rights, which is given effect by the Human Rights Act 1998, did not require the respondent to ensure that the appellants were provided with full compensation for having their property taken from them in the public interest. In our skeleton argument, we have used the analogy of property situated alongside a military facility. If the government considers that property adjoining a military facility should be taken into the public ownership or provided to a vetted private company in order to protect the national interest, we say it would seem clear that compensation would have to be paid at a fair market rate for the acquisition or the forced sale of the property. And we submit that the same principle applies in this case. There is one important distinction which puts this case in a different category entirely from other divestment orders made under the Act, and indeed from the analogy I've just given, which is that this case falls into a small window in which the Act applied retrospectively. Going forward, and indeed now, as I will show you, there are requirements for prior notification of transactions and acquisitions which may give rise to risks to national security, and if the requirements of the Act are not met, then such transactions are void. Having made those overview remarks, as it were, I will go through the facts relatively briefly.
Just before you do,
Yes.
that's a very helpful overview. Thank you for that. Can I just clarify one or two things with you about the overall structure of the case?
Yes.
Obviously, we read the judgment below when there were a great many grounds for judicial review being advanced. And as I understand it, what we're concerned with, and the only ground we're concerned with, is what was known as ground 1B below, which was to do with compensation.
That's correct.
Since you were challenging the final order in the judicial review proceedings below, presumably you would have been, if you had succeeded on some other ground, presumably you would have been seeking a remedy of a quashing order.
Yes.
But given that the scope of the appeal is now relatively narrow, what would be the remedy? If we allowed the appeal, what's the remedy you ask for?
Yes, well, I'll show you the pleading when we get there.
Okay.
But the answer to your question is that we ask you to remit the matter and direct that it goes for an inquiry as to damages.
Yeah.
And that on that inquiry, the court would need to consider what the appropriate measure of compensation is and look at the facts. And it would be a matter of applying the facts to the law.
Yeah, so you wouldn't be asking any longer for a quashing of the final order?
No, absolutely not, my lord. I'm sorry if that wasn't clear.
No. I thought that was the case,
Yeah.
but I just wanted to clear away what the case is actually about. Now on what you've just said, that you may not have meant exactly what I think I heard you say, but surely if we were to allow the appeal, surely we would have to state, either by way of a formal declaration or at least in the course of the court's judgment, what the basis of compensation should be. In other words, the only thing that would be left over would be quantum. We can't leave over the principle of how you should assess the compensation, can we?
Well, the way that the case was put below was that we're entitled to full compensation or fair value.
Yes.
And the judge below dismissed that.
Right.
Now, we say the judge below was wrong to dismiss that. But what exactly constitutes full compensation or fair value is obviously not a matter that you can address on this appeal. It's a matter of principle. So we submit that if this court finds that the judge was wrong in dismissing our claim to full compensation stroke fair value, then the matter should go back. The court below would need to look at principles of compensation, and it would also need, we've said this all along, almost certainly expert evidence on quantification of assets and so forth, and the court would need to reach a view. Can I make one other point?
Yeah.
We do put the case in two ways, and we always have. The other way we put it is that there was no process provided for in the final order for for establishing whether or not we've been fully compensated, and if we weren't fully compensated, for arriving at a figure that would fully compensate us. And that's, as it were, a second limb of the way we put the points, and that was also dismissed by the judge below. But we do say that there is a point of principle that arises on this appeal, and that point of principle needs to be decided by this court.
Well, that's helpful, Mr. Hickman. I don't want to prolong this preliminary exchange at all, but I think I ought to just mention this, at least speaking for myself only. I'm not sure, obviously we'll hear submissions about it, I'm not sure that full compensation is necessarily the same thing as fair value. So we'll have to hear submissions on both sides if you want to advance them, but just on the face of it. See, for example, I'm aware that one of the things you complain about is that you made a huge investment.
Yes.
And you, presumably by full compensation, you include the investment. But that's not necessarily how a company would be valued ordinarily.
Well, the evidence is that that was the book value of the company. So the amounts put in were how the company was valued and it appeared on the books. Now, obviously, we didn't obtain anything like that when the sale occurred. So we say that is one way of calculating our compensation, or what full compensation would be. But there are other ways of calculating it.
Yeah.
And of course, one is familiar in different contexts with different competing views about how to value it. Another way of valuing the loss might be trying to establish what the sale price would have been had there not been a forced sale.
Right,
if the market had not appreciated there was a forced
Yeah,
sale.
yeah.
So there would be competing ways of establishing the value,
Right.
and the judge would have to arrive at a conclusion as to which was the appropriate way, having regard to the Strasbourg principles.
Right.
And we don't suggest this is an exercise for this court, and it was common ground
I see.
that it wasn't an exercise for the court below.
I see. All right.
But the point is that the judge below said that's not an exercise that needs to be engaged in at all.
I see.
We bring down the drawbridge, you don't get to that stage at all.
I see.
And that's what we're challenging.
Yes, I see.
I mean, it's a practical matter. I think if this matter was remitted to engage in that process, there'd no doubt be discussions, and there might or might not be a settlement. There might not be, in which case that process would have to be gone through
I see.
by the court.
All right. Okay. Well, I'm sorry I interrupted you.
My lord, the facts. The facts are set out in paragraph 1 and 34 through to 81 of the judgment below. I'm not going to go through them all, but I will highlight some salient facts from my submissions. The appellants are part of the LetterOne investment group, as you will have seen, which makes long-term investments in companies operating in various sectors. The LetterOne Group Board is comprised of European and American nationals and chaired by Lord Davies, the former UK Minister for Trade, Investment and Small Business and Infrastructure. The membership of the Group Board is set out for your note at paragraphs 15 and 16 of Mr Gillespie's first statement in the supplementary bundle at pages 51 and 52.
Give me the paragraphs again.
It's 15 and 16 of Mr Gillespie's first statement. Supplementary bundle, pages 51 and 52. The appellants are, of course, distinct from their owners and from their ultimate owners. The owners of the group are a series of companies, and the ultimate owners of those companies are 3 Russian businessmen and to 2.7% a cancer charity. And the reference for that is Mr Gillespie's first statement at paragraph 21, supplementary bundle, page 54. The first appellant acquired 100% of the share capital of UP, which was then called Fibre Me, a non-operating UK company, for £100 on the 21st of January 2021 as a start-up investment. The plan was to build it up over 8 or so years and then sell it at a profit. And I do just want to show you very briefly Babcock 2, that's Mr. Babcock's second statement, which is in the supplementary bundle at page 85. Mr. Babcock is the Managing Director of Corporate Finance at the LetterOne Group. And I just wanted to draw your attention to paragraph 11, which sets out the investment plan in a nutshell. And you can see from the first sentence of paragraph 12, that by the date of the sale, which was less than 3 years into the business plan, LetterOne had invested 143.7 million into UP. And if you turn forward to page 97, Mr. Babcock also gives the figure for how much had been invested in UP at the time of the final order. That's at paragraph 38A. He says between the purchase and the final order, LetterOne had invested 96.7 million. This was effectively the book value to to LetterOne at the time of the final order. Now, before purchasing UP and starting to invest in UP, the appellants sought comfort from the government. They were not able to obtain formal prior approval under the National Security Investments Act because the Act at that point did not exist. And can I ask you to turn up the judgment, which is in the core bundle, page 111. The judgment is in tab 8, page 100 of the core bundle. And if you wouldn't mind turning, please, to 111. And you can see there's a passage of the judgment headed the assessment process at the top of the page. And you can see in October 2017 a consultation paper was published. And at the end of the paragraph 43, in November 2020, the Secretary of State published the government's response to the consultation. So that was the stage that had been reached. Then it says on 20th of December 2022, officials within the department met representatives of the group, that's LetterOne Group, to discuss the group's proposals for the acquisition of Fibre Me. And as I've said, Fibre Me became UP. There's one pure factual error which has no material significance, which is that meeting actually took place on the 9th of December. I think that's just an error that crept in that no one spotted it. The stage of checking the judgments. I don't think there's any issue on that. It's in the official chronology that was produced 9th of December. At the meeting, the group's chief executive officer, Mr. Jonathan Muir, sought to promote the group as already having a significant role in the UK retail sector through its ownership of Holland & Barrett. He provided a description of the group's governance structure and so forth, as I've outlined to yourselves. And then paragraph 45, during the course of the discussions, the group's external lawyers raised the issue of whether the Secretary of State would intervene, either under existing provisions of the Enterprise Act or the National Security Investments Act when in force. The unchallenged minute of the meeting reads as follows. The Deputy Director reiterated her comments during an earlier telephone conversation, i.e. that she had no particular concerns about the proposed acquisition. She could not imagine the Secretary of State intervening under existing legislation or calling this investment in under incoming legislation once in force. Then there was further correspondence, paragraph 47.
Could you read 46?
I have read it.
Thank you.
Well, is your reading 46, a point that I'll return to later, is the judge's comment in the penultimate sentence of that paragraph where she says the Deputy Director's comment in 2020 could not bind the Secretary of State in the changed geopolitical landscape of 2022.
I suppose there are 2 points. One, as we know, ultimately the decision was taken by the Secretary of State personally.
Yeah.
So officials can't bind the Secretary of State. But secondly, there's the point about changing world circumstances.
My Lord, yes, I'm not advancing a legitimate expectation case or anything of that nature. This is simply to point out that we're in a very different situation from people, from everyone else who's subject to the Act, because they have a formal process and we didn't have a formal process. And if it said that, well, we took a risk, well, we did everything that we could possibly do to ensure that we weren't taking a risk.
Right.
So could I ask you then just to read paragraphs 47 and 48?
I suppose it could be said that you did everything you could possibly do because you know that you knew that there was or might be a risk.
Well, my Lord, we did everything that we possibly could do. The way the Act works, I will show you, is it gives you reassurance. It gives a company certainty. So you know there's a way that you can establish in advance whether there is going to be a national security issue, and you can have that determined by the Secretary of State before the acquisition completes. And so you have certainty. But that wasn't available to us. We weren't in a position.
No, I follow that.
Just one further point. There's reference there to the Enterprise Act. We weren't within any of the categories of the Enterprise Act that would have allowed the matter to be called in. The easiest way of showing you that is to refer you to the explanatory note to the 2022 Act, which I've handed up and is in front of you. If you turn to page 6 of that explanatory note, it gives you an overview of the pre-existing position in paragraphs 13, 14 and 15. And the basic point is that in order for there to be a call-in under that Act, there had to be a relevant merger situation which required a turnover of more than 70 million or the merger results in the creation or enhancement of at least a 25% share of supply or purchase in or in a substantial part of the UK goods or services of any description. And paragraph 15, you can see reference to how those work in practice. We weren't anywhere close to being within any of those categories. So under the existing regime, there was no prospect of the matter being called in. The National Security Investments Act was enacted on the 29th of April 2021 and it was brought into effect on the 4th of January the following year. By that point in time, that is by January 2022, UP was operating in 8 market towns in East Anglia. That's recorded in the judgment, paragraph 35. In February 2022, Russia invaded Ukraine, and 4 of the UBOs of the appellants were sanctioned by the UK in March. And that's recorded in the judgment, paragraph 39. 2 resigned and sold their shares to a company whose UBO was one of the existing UBOs, Mr. Kozagov, who was not sanctioned and remains unsanctioned. And that's recorded in the judgment. That's paragraph 55. On the 4th of May 2022, the Secretary of State called in the decision. And if you turn the judgment up again, the reason that was given is set out. The Secretary of State reasonably suspects that a trigger event has given rise or may give rise to a risk to national security. Now, there's a point taken in the defendant's skeleton argument on the chronology as we've understood it. Can I just ask you to turn up the defendant's skeleton argument at core bundle page 36, paragraph 31C. They refer to our references to the invasion of Ukraine, and in response, what the defendant says is the appellants do not know the nature of the national security risk and when it arose. In any event, the assertions are contrary to the open evidence. So we've understood the invasion of Ukraine to be material to the chronology, and not least from the judgment, as I will show you. But the Secretary of State takes a point against us on that. I don't think it makes any difference, because the key point is, as the Secretary of State emphasises in that paragraph, the appellants even now do not know the nature of the national security risk and when it arose. But just so that you can see in the judgments the references to Ukraine, I've already shown you one occasion where the judge refers to the changed geopolitical environment in 2022. If you look at paragraph 38 of the judgment, the judge refers to the invasion of Ukraine, paragraph 38.
Sorry to interrupt. Is it your case that the nature of the national security risk, which you accept you're not in a position to know about, is entirely irrelevant to the issue in the appeal as to the extent of compensation which should be paid?
Well, we on the basis of what we know about the risk, which admittedly is not very much, we say it's irrelevant. And we say that because it doesn't relate to anything that concerns wrongdoing or inappropriate conduct by us. Okay, and so far as we know about the national security risk, what we know is that it's concerned with the possibility that the ultimate beneficial owners of the companies that I represent might be open to leverage by the Russian state. So we don't know the precise nature of that, how the government thinks that would occur, or how the government thinks that would filter up the chain of ownership. But we say, in response to my Lord's question, the national security risks are, in a sense, irrelevant to the question of compensation, because it's not said that my clients have been engaged in conduct that is a danger to national security, as it might be in a terrorism case, for example.
Well, you say it's not said. Yeah. If you don't know what the nature of the national security risk that was taken into account is, how are you able to say that
Because we know
there was no risk of wrongdoing on the part of the UBOs in this case.
well, the UBOs are not my clients.
No.
I'm not. I don't exactly know what's said about the relationship with the UBOs, but we know enough about the national security risk to know that it's not about nefarious things that we're said to have done. So I can show you that. I will show you.
Well, we're talking about risk rather than.
Yes.
The decision is made on the basis of risk, not necessarily on what has happened in the past, although obviously that informs risk.
But the relevance of it is this. When I show you the principles on Article 1 of the First Protocol, you will see that obviously there are situations where someone's property is taken away and it would be inconsistent with the reasons for doing that to compensate them. So let's say somebody's been involved in serious crime and their property is taken away because it's suspected that that's the proceeds of serious crime. Well, obviously it would be inconsistent with doing that to compensate them. But from what we know about the national security risks in this case, it would not be inconsistent to compensate us for taking away our property in the public interest.
Well, what we know anyway, it may be the same as what you know, or been told, is that the decision was taken based on a risk of being susceptible to influence. I think the word is leverage in the order itself. And that, it may be said, well, that is an expression which might cover a vast range of different levels of culpability. It might involve someone who is, or might be regarded as having very little culpability because they are innocently susceptible to coercion or influence. Or it might include someone who would fall within the broad description of bad actor, who was an enthusiastic and willing participant in a state abuse of the fibre network for spying or disruption of the infrastructure. And those might be different ends of a spectrum of the risk of the behaviour of the UBOs in bringing their influence to bear on how the company conducted itself. But if we don't know which end of the spectrum it is, how are we able to say that it's not akin to a risk of somebody essentially being prepared to indulge in criminal activity?
Well, my lord, I think there are a number of answers to that. First of all, you're talking about the UBOs.
Yes.
The UBOs are not the appellants.
No.
So the critical thing is that the appellant's assets have been taken.
Yes.
And it's very clear that it's not said that the appellants are in any of those categories. It's not said the appellants are susceptible to leverage by the Russian state or anyone on the board of LetterOne Group. What's said is that the ultimate beneficial owners, the shareholders of various intermediary companies, could be susceptible, and then that they would use owner influence, in other words, their ability to exercise their ownership rights over intermediary companies to ultimately, presumably, affect changes to LetterOne, which could then be used in a...
Yes, your clients would be the instrument, as it were, not the bad actors themselves.
That's right.
Yeah.
But in any event, I mean, if the judge had relied on any reasoning along those lines, the judge would have had to have indicated that the reasoning in relation to Article 1, Protocol 1 was based on closed material. And there's no suggestion of that at all. The judge's reasoning was squarely based on what's available to all of us in this court, the open evidence. The Secretary of, were that not the case, the Secretary of State would have applied to this court to have adduced closed evidence to this case, and hasn't done so.
Thank you.
So, paragraph 46, I've already highlighted the point there where there's reference to changed geopolitical environment. And finally, and this is the only reason really for making the point, it feeds into the reasoning on A1P1, and I'll take you to this later, but if you look at paragraph 225, in the, again, the penultimate sentence, reliance was placed by the judge on the fact that geopolitical crises may affect the viability of investments. In October 2022, the assessment period was extended for an additional period ending on the 22nd of December 2022, and that's in the judgment, paragraph 63. Perhaps we can just quickly look at that, because at this point a little bit of further information was provided to my clients about the nature of the national security risk. It was 10th of October 2022. And in the indented passage, second sentence, the national security risks in this case relate to the ownership of up by the ultimate beneficial owners, specifically to the indirect ownership of the existing and growing full fibre broadband network rolling out in the east of England. And then the letter informed my clients that various measures were under contemplation, set out in Roman 1 through to 4, the fourth of which was requiring divestment. Written representations were made by my clients on the 24th of October 2022, judgment paragraph 67, and 15th of November 2022, judgment paragraph 70. As you will have seen, the appellants argued that national security risks, as they've been articulated in that letter, could be addressed by restricting shareholder rights over up and preventing disclosure of information of certain types to its directors, as well as through other mechanisms. Those submissions were not accepted. The final order was made on the 19th of December 2022, shortly before the end of the additional period. And I would like to show you that. It's at the core bundle at the back, page 404. So first of all, you will see that from the very first paragraph under the heading, failure to comply with the notice is a criminal offence. The recital set out the very potted chronology of events which we've been through. There's then, in paragraph 3 over the page, a decision. Now I should emphasise there's no separate decision letter, there's no separate reasons. This is what was sent to my clients. Secretary of State makes the final order. Then there's a statement of the national security risks in 3B. And the conclusion is that there should be divestment of 100% of the shareholding. And it's stated that the Secretary of State orders L1T FM to divest 100% of its shareholding in UP, in accordance with the process and deadlines set out in the order. The process and deadline is set out in paragraph 5 over the page. Again, we see in little a requirement that L1T FM shall divest 100% of its shareholding, and then a requirement within 30 days to produce a disposal plan. That's reviewed by the Secretary of State, and essentially any comments or requirements of the Secretary of State need to be taken on board. And the process is gone through again, if you look at E, until the Secretary of State is satisfied with the disposal plan. Over the page, at H, If the disposal plan is not approved, the Secretary of State may require L1 TFM to comply with a disposal plan determined by the Secretary of State himself. And then at I, a requirement to effect the disposal in accordance with the approved disposal plan during the divestiture period, which, if you look at J, is 9 months. Paragraph 7 of the order deals with potential purchasers, and I won't go through it in detail, but essentially notification of any potential purchasers has to be given to the Secretary of State. The Secretary of State has an ability to veto on grounds of independence, capability, or national security the purchaser. Paragraph 9 provides for a monitoring trustee to be appointed. And then if LetterOne is not pursuing disposal in the manner required by the Secretary of State, paragraph 10 permits the Secretary of State to appoint a divestiture trustee to bring about the disposal in the alternative, so they can take over the process, essentially.
Is the final order a public document or a publicly available document?
Yes, I believe it is.
So
I'll double check that, but my recollection is
obviously I'm aware that it's become public for whatever reason, but the scheme envisages, does it, that when it's made, others, members of the public, including potential purchasers of the company, will be aware of it.
Yeah, the purchaser was certainly aware of it.
So it's not, as it were, you would say, it's not the same scenario as when there's a willing seller.
No, absolutely not a willing seller, willing buyer. Absolutely, that's the key point. So the amount obtained is massively affected by the fact this is a forced sale, and people are aware that there's huge pressure to sell and requirements to sell. Finally, paragraph 15 at 412, permission to challenge the order by way of judicial review, but there's a statutory requirement, section 49, that it's brought within 28 days of the final order, which was complied.
Yeah.
I see that in 5B, under divestment, there has to be an indicative valuation of that and a list of its assets. What's the purpose of that?
Can I come back to you on that? Taken.
And what was the valuation that was given in this case?
I'll double check.
And perhaps allied to that, was it a valuation which was linked to the disposal plan, so that it was a value by reference to the manner of disposal contemplated, or was it a wider?
I don't have the answer to those questions at my fingertips, but I'll find out the answers and come back to you. I may.
Since we've interrupted you, Mr. Hickman, can I just ask you, have you agreed with Sir James a timetable for today?
Haven't, my lord. I was thinking I'd be relatively quick with my submissions, but I have to admit, so far, taken longer than I was anticipating.
No, well, inevitably the court has questions for you, but if I were to indicate that we would expect you to complete your submissions by 1 o'clock, would that be satisfactory to both of you?
My lord, that's what I was anticipating.
Very good.
And then if I could just ask you to turn back to the judgment, paragraph 81, to complete the story, as it were. On 5th of September, Up was sold to Virgin Media 02. The group received less for the sale than the 143.7 million that it by then had invested In a witness statement, Mr. Babcock sets out cogently how the fact of the forced sale was bound to result in a sale price that was below the true economic value of up. That's paragraph 81 of the bundle. And could I just ask you again to turn up the supplementary bundle at 87, Mr. Babcock's statement. And in particular, can I highlight paragraphs 19 and 20 at 87 and 88. And then there's a section of Mr. Babcock's witness statement where he deals with requests that were made after the final order for financial assistance in supporting up through to the sale. And he deals with that from paragraphs 21 onwards of his witness statement. I won't take you through all of that because in my submission it's not really relevant. But if you look at the first sentence of paragraph 21 and the second sentence of paragraph 21, you see the points. And just to indicate the Secretary of State's position during that process, if you turn to paragraph 34 of Mr. Babcock's second statement at page 94, the conclusion of the Secretary of State's letter on 13th of June 2023, a failure to fund pre-existing funding commitments leading to insolvency and a greater potential loss would constitute a failure to mitigate your losses. We consider that any additional loss caused by withdrawal of funding would also be found to be a break in the chain of causation between any alleged claim for breach of statutory duty by the Secretary of State and any damage that LetterOne might allegedly suffer. So essentially the point that's being made by the Secretary of State is you have to keep funding it to mitigate your loss so that you get through to a sale. You get some money back. Can I just one last document?
We don't know, do we, the amount of the sale? That seems to be redacted.
Yes, the amount of the sale is available to you. It's confidential information that we requested up, particularly. We can give that to you on a piece of paper. There's no difficulty with that. There is a confidentiality order that was made below that applies to it, and that's why I'm not going to state it in open court. And rather than seek a variation of that order, I think the sensible thing is that at lunchtime I just provide you with a document that just has the number highlighted, if that's okay with you.
Yes, that's fine.
Then, just to show you one of the key documents that was produced by officials for the Secretary of State, which is in the same supplementary bundle at page 27. This is a document known as the remedies assessment, referred to in the judgment at paragraph 75. And this was provided to the Secretary of State, and essentially it compares the two different options. One was remedy A, which is divestment, and the alternative was remedy B, which was putting in place a series of measures that would seek to insulate up from any owner influence. And you can see, and I emphasise, we didn't receive this document until during the course of the judicial review proceedings. So this is not material that was known to us at the time of the assessment process. National Security Risk Summary at page 27. And you can see it's leverage of the ultimate beneficial owners, and then potential influence up through the chain of ownership. And it said that although four of the beneficial owners have been sanctioned, the sanctions might in the future be lifted. At that point, LetterOne would be free to return shares and control to those entities. And then over the page, paragraph 2, the core recommendation. You are recommended to impose remedy A in this case because the ISU deems it to be the most effective at mitigating or preventing the national security risks in this case. It carries the highest expectation of compliance despite the high expected cost to the parties of this remedy. And then just to show you one part of the analysis, if I can ask you to turn forward to page 31. There's a table, and one of the headings in the table is enforcement. LetterOne would be forced to find a buyer within a specified time. This is analysing divestment, with HMG able to take enforcement action if LetterOne fails to agree a sale within that period. It would be unlawful to retain ownership of the company. The final order which prohibits LetterOne from retaining ownership is legally binding. Any evidence to the contrary would be the basis of enforcement action. And then, not the next, but the subsequent box, costs to the parties. The final order would prohibit continued ownership of Up by LetterOne. LetterOne would highly likely incur high cost in selling Up, as it would highly likely receive less than the amount at which it values the company and the investments they have made in Up. Prospective buyers will be aware through the final order publication notice and subsequent due diligence that the sale is being compelled by HMG. There could be a perception this is a distressed sale, and this could bring about the price offered being different than the market value.
Mr. Hickman, can I just ask you about that? Because this is a point that features in several places, I think, including the judgment. The point is made there, highly likely receive less than the amount at which it values, in other words, the appellant values the company. But does your submission turn on the person who's doing the valuation? Presumably you would make exactly the same submissions to this court if, for example, there were an independent expert witness who valued the company.
That's essentially right, Michael. We're not saying it has to be our valuation. Of course we're not that. There is an objective valuation of the company. There are different ways of arriving at an objective valuation. And we would make our submissions as to how the company should be valued to somebody who was in a position to take an independent view on that. And that's exactly what we say should have happened and should happen. We say there should have been something built into the final order which allowed that to happen. Because, of course, at the time of the final order, it was conceivable. We would have done very well out of the sale. It's conceivable. And so there should have been something built into the final order for an independent person to assess whether or not we'd achieved compensation, and if not, for that person to arrive at a fair way of valuing the asset so that we could be compensated for the difference. In the absence of that, the best we can do is bring our claim under the Human Rights Act, as we have, and seek just satisfaction under Section 8 of the Act, which essentially would involve a court doing the exercise that I've just described.
Do you say that the government would be bound to do that in every case? Or would it be open to the government to say, we think a sale in this case will realise a fair value?
Well, our point is that it's only in cases, and it may be, this is the only one, and maybe there's one other, where the Act was applied retrospectively, that this issue arises at all. Because in other cases, you go and get your permission before you engage in the acquisition. So the point doesn't arise. only arises here because we're in this very strange situation of the Act having applied to us retrospectively. So it wouldn't, I'm certainly not saying that every time the Secretary of State orders divestment under the Act, there would need to be that provision, because it may well be that it's totally unnecessary under the Act as it applies prospectively. Does that answer my Lord's question?
Well, it is an answer, but we'll look at the notification provisions.
Yes.
And have to bear in mind that there may be cases in which people don't know whether they ought to notify or not. But we'll come to that.
Well, let's have a quick look at the Act then. Authorities bundle.
So had you finished on the facts?
Yes, that's it. On the facts.
Right.
So I am going to have to, as it were, emphasise certain important points rather than take you through all of it, because obviously there isn't time to do that. Can I just take you to page 38, which is the beginning of the statutes. Section 1 allows the Secretary of State to give a call-in notice where certain trigger events have occurred, or where arrangements are in progress or contemplation which will result in a trigger event. It's section 2.4, section 2, subsection 4, which is the section which gave the Act retrospective effect to my clients. So there's a window in which it had retrospective effect, and we were within that window.
Presumably the date of the 12th of November 2020 was chosen for a good reason.
I can't answer that question.
Well, we can have assistance from St James if necessary in due course, but it's not completely retrospective.
No, there's a window.
And this often happens in the tax context, for example, that when you have a statement in a budget, the Finance Act usually obviously follows some months later, but it's conventional practice to take the view that you've given notice to the citizens from the date of the budget, what is likely to happen. Therefore, there is, to that extent, there's fair notice.
Well, there's
the thinking.
Yes, a degree of. I mean, you've seen this sort of. We're still just finished the consultation stage at the point at which we approached the Parliament. But critically, we obviously don't object. We haven't objected and said that there's something fundamentally wrong with the Act having retrospective effect. It just means that we weren't able to exercise the prior notification provisions.
Yes.
So, section 5.
I see from the explanatory note that an impact assessment was published on the 11th of November 2020. I don't know if that's anything to do with the date.
May well be. So, a trigger event is defined in section 5. Person gains control of a qualifying entity, as set out in section 8, or a person gains control of a qualifying asset, as set out in section 9. And then there are a category of situations which are called notifiable acquisitions, which must be notified to the Secretary of State. And section 6.2, a notifiable acquisition takes place when a person gains control by virtue of one or more of the cases described in subsection 2, 5 or 6 of section 8. That's not all of the relevant subsections of section 8, of a qualifying entity of a specified description. And there are regulations that have been made under this provision which gives further detail. And subsection 4, description of a qualifying entity that is specified must include provision that the entity carries on activities in the United Kingdom which are of a specified description. Essentially the way this works is that the regulations set out 17 different areas of the economy which are of a sensitive, or regarded as potentially of a more sensitive nature. And if you're within one of those, and one of the and you gain control by virtue of one or more of the cases described in subsections 2, 5 or 6 of section 8, there is a notifiable acquisition. And Section 8 sets out 4 cases where there is a relevant acquisition. Subsection 2, the first case is where there's an acquisition of a certain number of shares, from 25% or less to more than 25% and so on. Obviously that applied in our case. The second case is at subsection 5. The percentage of the voting rights increases by certain boundaries. Third case is where the acquisition of voting rights allows you to secure or prevent the passage of resolutions. And then the fourth case in subsection 8 is where the acquisition, whether alone or together with other interests or rights held by the person, enables the person materially to influence the policy of the entity. And then if you turn to page 46, within chapter 3 of the statute, section 13 provides that a notifiable acquisition that is completed without the approval of the Secretary of State is void. So if you haven't gone and got your approval, or if the Secretary of State hasn't called it in, and you go through with the acquisition, then it's void. And then at section 14, subject to subsection 2, a person must give notice to the Secretary of State before the person, pursuant to a notifiable acquisition, gains control in circumstances falling within section 6.2. So there's a process there in which notifiable acquisitions of certain type must be notified. And as we've seen, a notifiable acquisition that doesn't have consent is void. If you do go through with the notifiable acquisition and it's void, there's a process in section 16 for seeking to retrospectively validate the acquisition. And then in section 18 at page 50, there's what's called a voluntary notification procedure. And this applies in situations where there's no mandatory requirement to notify. So in wider circumstances, so perhaps that don't fall within those 17 categories of the 17 parts of the economy specified in the regulations, the person is concerned that there is nonetheless an acquisition that would be a trigger event because of the number of shares or number of voting rights that have been acquired, and they think there might be a risk to national security that the Secretary of State might be concerned about, they can voluntarily notify to obtain certainty. During the process of assessment, the Secretary of State has a very set of formal powers. Section 19, power to require information. Section 20, attendance of witnesses. And then Section 23 sets out that the assessment period within which the Secretary of State must come to a decision and produce a final order if they're going to make a final order. Nothing really turns on that, but I've shown you that on the 10th of October there was an additional period notice, and that was issued under subsection 8 of section 23.
Is the way this works that if you comply with this notification procedure and the Secretary of State accepts the notice and says that no further action will be taken, then he can't change his mind if geopolitical circumstances then change. So if he had given approval back in 2020,
Yes.
and then Russia invades Ukraine and he views matters in a different light, it's too late for the Secretary of State to do anything under this Act. Is
That's right. If a final order has been made of some description, that can be kept under review, and there's some provisions that allow that to be amended. But if it's been approved, it's been approved. Just on final orders, section 26 is the power under which final orders are made, and given that one of our arguments below was that the final order ought to have had a process in it for allowing an assessment as to whether or not we'd obtain fair compensation, subsection 5 is very broad in the terms that it allows a final order to be made in, and we say it's ample to allow a provision of the nature we proposed. And then two final provisions. Section 30 is the financial assistance provision, which allows the Secretary of State to give financial assistance which can be loans, guarantees or indemnities or any other kind of financial assistance. So the Secretary of State could have put in the final order some form of indemnity, if, for example, we did not obtain full compensation in the sale. And finally, at section 33, there's the offence that I already mentioned when I showed you the final order, failing to comply with the final order.
So, I'm so sorry to take you back to section 30, subsection 1.
Yeah.
I may have misunderstood the point you're making, but on the face of the wording, it says, in consequence of the making of a final order.
Yes.
So, are you saying that it could have been used in the final order?
They could have put in the final order some form of guarantee or indemnity, which is under section 2,
Yeah.
subsection 2,
Yeah.
saying that if you know, as a consequence of this final order, full compensation is not realised during the sale process, then we will provide indemnity.
I see. But I think I don't know if it matters, and tell me if on your submission it does not matter. But certainly the judge seems to have thought that it was of some significance that there had been a decision under section 30 which had not been challenged. And I suppose it might be said, well, if your fundamental practical concern is that you have, as it were, lost financially, then you could and should have applied for financial assistance, and that hasn't been done, as I understand it.
It doesn't matter. In my submission, it is a red herring at this point. Not least because we hadn't sold, at the point at which we applied for financial assistance, we hadn't sold the company. So we didn't know how much was going to be realised. So the loss that we suffered in selling, being required to sell the company, hadn't arisen. The financial assistance that we applied for was not equivalent to this claim, which is we would like financial assistance to make up the difference between the objective value of the asset and what we realised. Financial assistance was just to help us continue to fund while we were in the divestment process. It was for a different request.
I appreciate it was a different request, but what I'm asking is, as a matter of legal principle, on your submission, would section 30 allow someone to make a claim, effectively the sort of claim that you're making in court?
After the, well, that's effectively what our claim. I mean, we have brought our claim saying that this should have been included in the final order. The Secretary of State could have settled our claim by saying, well, fine, I'll pay the difference now, but the Secretary of State has resisted that.
Okay, I interrupted you. You got to section 30, and where were you going?
Yes, I was just going to quickly show you the criminal offence.
Oh, yes.
Which is over the page.
33.
Yes.
Right.
And then what I'd like to do is turn to the Article 1 protocol.
I'm sorry to slow you down, but just going back to notifiable acquisitions.
Yes.
Have I understood the Act correctly? I may well not have done that. Notifiable acquisitions are defined in regulations and so on, but they are not the yardstick which controls whether the Secretary of State is entitled to call matters in and
right.
make an order. So if geopolitical circumstances change, there may be an area of economic activity or a particular company which wouldn't fall within the notification regimen, and the Secretary of State may be able to impose an order on them.
No, only if there's another trigger event. There'd have to be an acquisition. So there'd have to be a change in the shareholding of the company or something like that, which would constitute a trigger event.
Yes.
Then they call it in. They can't
Yes.
just...
But it would be a change in acquisition, which wouldn't make it a notifiable acquisition.
Well,
I'm just trying to examine your suggestion that this isn't a problem that's ever going to recur because of the notification provisions. And as I understand it, that may be so if all the Secretary of State is ever going to do is call in acquisitions which fall within the regulations.
yes.
But if geopolitical circumstances change,
Yes,
the
so
Secretary of State is not so limited, is he or she?
What would happen is, and it does happen, that the Secretary of State receives an awful lot of voluntary notifications. So if people are engaged in a transaction which constitutes a trigger event because they're purchasing over a certain number of shares in a company, they can notify that voluntarily to the Secretary of State. The Secretary of State can decide whether to call it.
No, I'm on a slightly different. Suppose there's an area of economic activity which hasn't previously been identified in the regulations as
Yes.
giving rise to a risk,
Yes.
but it suddenly appears that it does. Some factory makes some particular component which wasn't thought to be of any significance, and it suddenly realised that it does. There's an acquisition in relation to it. The Secretary of State can call that in and impose an order for divestment, even though that has never been a notifiable acquisition. Is that right?
My lord, yes, but my point is that if you're working in that sector, you should be aware that there might be a risk. So if, for example, there's been a sudden, something geopolitical means that we've run out of a certain product, and you're thinking of buying a company that makes those products, and you know that there's a shortage of them.
Well, you may be right. But if I'm making a particular electronic component, and it then appears to the security services that a hostile actor is using that particular type of component for their weaponry, as the manufacturer, I may not be aware of that at all. No?
Well,
anyway, I'm going down a line which
I
may not be of any importance. It
Obviously,
really only goes to your floodgates argument.
Yeah, companies obviously these days spend an awful lot of time if they're engaged in anything which could be a trigger event, buying a certain number of shares or changing voting rights, in establishing whether or not they should or should not make a voluntary notification. And my understanding is that an awful lot of them are made, no doubt, because people are, want to be 100% sure.
Right, thank you. I'm sorry to have taken
So,
up your time.
I said I'd show you the pleading on A1P1, and perhaps I can very briefly do that. It's in the core bundle at 394. Paragraph 71. And just to flag that this was amended, and the reason for that was obviously because it was initially pleaded before the sale, and then after the sale, further pleading was introduced. Paragraph 79. Can I just emphasise the first paragraph, 79, as it were, 79 proper? Just ask you to read that, and 79D. So you'll see the two ways we put it. First of all, we say there was a deprivation of possessions, that A1P1 requires full compensation or fair market value, and that in the absence of that, we're entitled to recover as just satisfaction under the Human Rights Act. And the second limb, as it were, is that the final order did not include any procedure by which compensation could be assessed objectively once the sale had completed if it failed to realise.
And 79E is important because that makes it clear that in this context, all you are seeking is a declaration and an order for an inquiry as to damages.
Yes.
In other words, if this ground had been accepted, and only this ground had been accepted, you were not saying that the final order needs to be quashed.
My lord, yes, that's why I answered your question earlier in the way
That's
that
very
I
helpful.
did.
But the declaration would need to identify, wouldn't it, what the basis was for the inquiry as to damages, not in a quantification sense,
Yes.
but whether it is full compensation, fair value, market value, or some other expression.
Yes, well, one could take from the Strasbourg authorities, which I'm going to show you, the terminology, if one was so minded, or one could just, I mean, it's clear that we did not obtain any of those things, so which says, well, whichever target one's aiming for.
I think in your earlier submissions you used the expression fair value.
Fair value. The principles, the core principles can be taken from the judgment of Lord Carnworth, with which the other members of the Supreme Court agreed in Mott and the Environment Agency, and that's in the first authorities bundle at tab 7 at page. Sorry, no, it's not. It's in the second authorities bundle. I'm so sorry. So it's tab 11 of the second authorities bundle. And if I could just ask you to turn to page 792. There's a heading A1P1 Principles. A1P1 is set out. Lord Carnworth then says, paragraph 18, the general principles governing the interpretation of A1P1 are established. The Strasbourg Court explained that it comprises 3 distinct rules. The first, in the first sentence, is of general nature and enunciates the principle of peaceful enjoyment of property. The second, in the second sentence of the same paragraph, covers deprivation of possessions and makes it subject to certain conditions. And the third concerns the rights of states to control the use in accordance with the general interest. Just pausing there, our pleaded case is firmly within the second. We say we're in the second category. I mean, if we're not, we fall out into the third, but my submissions are we're in the second. It's a deprivation. The 3 rules are not distinct of the sense of being unconnected. The second and third rules are concerned with particular instances of interference. And then can I also just ask you to read the first sentence of paragraph 20, which is cited approvingly from a judgment of Lord Justice Newburgh, as he then was, in the Trailer Marina case, giving the judgment of the Court of Appeal. Said he reviewed the authorities dealing with the distinction between taking or deprivation of property and mere control of use. As he noted, the former normally requires payment of compensation to avoid a breach of the article, the latter does not, even if the control results in serious financial loss. So we're in the former category. Can I then ask you to take a further principle from a Grand Chamber judgment in the case of Vistin, which is at tab 25. And if you could turn, please, to paragraph 110 of that Grand Chamber ruling. paragraph 110 says that compensation terms under the relevant legislation are material to the assessment whether the contested measure respects the requisite fair balance, and notably whether it imposes a disproportionate burden on the applicants. The court has already held that the taking of property without payment of an amount reasonably related to its value would normally constitute a disproportionate interference. In many cases of lawful expropriation, such as a distinct taking of land for road construction or other public interest purposes, only full compensation may be regarded as reasonably related to the value of the property. And that's where I say we're in the context of, as it were, lawful expropriation, because the order has otherwise been affirmed, it's been made under legislation, but the principle is that there should be full compensation.
Is there a distinction between expropriation when the state acquires the property,
Yes.
and therefore gets for itself the value of the asset, and in general ought therefore to pay for it, and compulsory deprivation where the state doesn't get anything and the party divesting is allowed to keep whatever it can get on the sale of its asset?
Yeah, no is the answer to that, and I'll show you why. And that just for your note, you'll see it in various authorities I'll take you to. The Strasbourg court uses the word expropriation even in cases where property is being transferred under compulsion of law from one private individual to another. James in the UK being an example. So it uses that phrase in that context. Also, paragraph 111. Moreover, the court reiterates that where an individual's property has been expropriated, there should be a procedure ensuring an overall assessment of the consequences of the expropriation, including the award of an amount of compensation in line with the value of the expropriated property, the determination of the persons entitled to compensation, and the settlement of any other issues relating to expropriation. And that's where we get that principle from.
This is presumably in a rather commonplace context, if I can put it that way. In this country, we're very well used to compulsory purchase orders, right, for the making of roads or for some other public infrastructure purpose. That's very commonplace. We've had it for decades, if not longer. And there's a well-established scheme for compensating people there. But I'd be surprised if in that context, if, say, an investor has spent a lot of money in an investment project, but actually at the end of the day, the value of the property which is compulsorily purchased is nowhere near what they've invested in it. Presumably, our rules on compulsory purchase would say that yes, you do get full compensation, but full compensation means the value of the property now, with a willing seller and a willing buyer.
Yeah. Well, as I've said, there are different ways that these things can be calculated, but we don't need to get there because we don't even have a willing seller and a willing buyer. So, you know, as it were, I'm not asking this court to work out what is the correct way of valuing the objective value of the property. But we say that exercise does need to be gone through, and that the judge was wrong to simply say, well...
No, I understand how you put your case, but I'm just trying to understand what's meant by full compensation. That, as I understand it at least, it doesn't mean the value of the investment, which may well have gone down. What it means is the asset is the house. I'm very used to this. You know, houses get knocked down to build a motorway.
There is an authority, which I'm going to show you, which shows that it can go beyond that.
I see,
Okay. But in any event, the value that's been invested into an asset is not an entirely relevant matter when one's thinking of the value of the asset objectively and what a willing seller and willing buyer would agree for it.
Right.
Because obviously, if you've got something that you've invested a lot of money in, that's going to affect the operational value of the asset.
Yeah. But on the other hand, I think would you accept this, that it's commonplace in this country that from time to time, local planning authorities, for example, introduce local plans for their area, which may well have a devastating impact on the economic value of a piece of land, because if it's designated for agricultural use only, its value may well be very different from if it's designated as a site for housing development. But that, would you accept that that's all control of use?
That's control of use.
And there's no presumption even, let alone rule, that there has to be compensation for those sorts of measures?
There's certainly control of use, but whether or not there would have to be compensation depends. I mean, there is a case, namely, I think it's Freya, where there was the government announced a consultation about solar subsidies,
Right.
and that massively affected the value of some of those companies and basically destroyed them. And this court found, I think, in principle, that was an interference with A1P1 that might give rise to need to compensate and dig out the authority. So I don't accept that this it's just a sort of universal rule that there's never any compensation. So we rely on those two paragraphs from the Grand Chamber judgment, and then can I deal with situations where you may be able to obtain, as it were, losses that go beyond the market value, and the circumstances in which full compensation is not required, even where there's a deprivation of assets. Now, in relation to the first of those, can I ask you to turn to the judgment?
So when you say losses beyond market value, is market value something different from fair value?
Let me show you the authority, my lord, and I'll make my submissions on that. It's Osmanyan and Armenia. It's at tab 21 of the authorities bundle. This was a case about a plot of arable land that was farmed by a family, which fell within a zone that was going to be used for copper mining. And you pick the facts up from paragraph 6 through to 13. And although this was within what was called an expropriation zone, the property was actually, this goes to my question I was asked by Lord Justice Mayles, and I'll come back to it in due course, about whether it makes a difference if the ultimate beneficiary is private or public. Here was an example of a private company, and you see that from paragraph 11 and 13. That a company that was going to benefit from the mining brought an action to obtain this land, made an offer which was refused. The court, paragraph 16, upheld the company's claim and awarded some compensation. And the matter then goes up and down to the appeal courts, but ultimately that result remains in place. And if you turn forward to paragraph 47, it's buried, I'm afraid, in the middle of that paragraph. There's a sentence that starts, they argued it was manifestly unreasonable in the present case to rely on a public interest when the measure had an exclusively commercial purpose, taking into account that the mining project was being implemented by a private company which did not have any state participation. So it just emphasises the point that this was a company that had brought the proceedings under the law to obtain the land. The court finds at paragraph 49 that it's nonetheless a deprivation of possessions within the meaning of A1 P1. And then, in terms of the compensation principles,
Forgive my ignorance, but what does cadastral mean?
that's the land registry value. So it's as I understand it, it's some sort of official value of the land.
Thank you very much.
Paragraph 69. The court considers that there may be situations where compensation representing the market price of the real estate in question, even with the addition of the statutory surplus. Here there was a under the law, they had to add 15% to the cadastral value of the land to the compensation, even with the addition of the statutory surplus, would not constitute adequate compensation for deprivation of property. In the court's opinion, such a situation may arise, in particular, if the property of the person was deprived of constituted his main, if not the only source of income, and the offered compensation did not reflect that loss. And then paragraph 70 refers to the fact they depended economically on the land, and then halfway through paragraph 70 there's this sentence: the courts decided that, despite the circumstances, the applicants should be provided with compensation which was determined in relation to the price of real estate situated in the area subject to expropriation. They did not address the issue whether the compensation granted would cover the applicant's actual loss involved in deprivation of means of subsistence, or was at least sufficient for them to acquire equivalent land within the area in which they lived. In view of the foregoing, the court finds the applicants had to bear an excessive individual burden. So we do say that that means that there is a margin in which one can argue, if you've suffered losses that aren't fully compensated in an assessment of market value, that they could be recovered. But, as I said, in this case it doesn't matter because we haven't got even the market value, because there wasn't a willing seller and a willing buyer. Then, what circumstances might compensation not be payable? And in my submission, this issue is determined by this court's judgment in SRN Global Master Fund, and that's in Authorities Bundle 12 at page 799. The judgment of this court was delivered by Lord Justice Laws, with the Master of the Rolls and Lord Justice Waller in agreement. It concerned the nationalisation of Northern Rock, which was done by an Act of Parliament in 2008. The claim was brought by former shareholders of Northern Rock. They were compensated under the 2008 Act, but they argued that the basis for compensation failed to afford them full compensation. So if you turn to page 803, you can see first sentence of paragraph 3, the appellants were all shareholders in Northern Rock. You then get further details which we don't need to look at. Paragraph 5, under the indented quote, Northern Rock's assets were substantial, certainly exceeding its liabilities. Its mortgage loan book was sound. It was solvent in balance sheet terms, but it was unable to meet its debts as and when they fell due. Then I'm afraid in this next sentence something's gone wrong with the printing. I'm going to ask you to cross through some words. Unless it obtained a large injection of funds, it would almost certainly, and then the words then need to be crossed out until you get to the words be put into some form of insolvency. I'm afraid I've got absolutely no idea what's happened there, but otherwise it's complete gobbledygook. So unless it obtained a large injection of funds, it would almost certainly be put into some form of insolvency procedure, and there would be a fire sale, liquidation of its assets. So the point being made is, well, we didn't get enough money for our shareholdings under the Act because they were fundamentally valuable, and we got very little. The court then deals with why Northern Rock was nationalised, and it was first of all put into a lender of last resort scheme, and then it was subsequently nationalised when that wasn't sufficient. But what's important is the reasons why it was put into the lender of last resort scheme and subsequently nationalised. And if you look at paragraph 8 on page 804, Lord Justice Laws says the principles on which the lender of last resort is provided are explained in a well-known lecture given in 1993 by the then governor. And the points I wish to highlight are, first of all, the third sentence of the indented quote. The possibility of failure is necessary to the health of the financial system as it is to the efficacy of all economic activity. Any aid to a present bank is the surest mode of preventing the establishment of future good banks. And then under the heading on the next page, principle of last resort assistance, the overriding principle is not new. Our support, whatever form it takes, is directed to safeguarding the financial system and therefore preventing damage to the wider economy, not the institution itself. So the point is that the intervention of the government and Parliament was not on the basis that it felt it should step in to protect the shareholders of the bank, but purely to protect the wider economy. So then you get facts, which I don't have time to go through, by which they're put into national ownership. The legislation came in 2008. Can I just highlight one point here at page 813? This is in section 5 of the Act, which is set out on page 813, and in particular section 5.4. This set out the principles on which compensation for shareholders was to be based. In determining the amount of any compensation payable, by virtue of any provision in any order under this section, it must be assumed that all financial assistance provided by the Bank of England or the Treasury in question has to be withdrawn, and that no financial assistance would in future be provided by the Bank of England. So essentially what's being said is when you value the shareholdings and the compensation, you have to totally leave out of account any financial support that's provided by the state. That provision was the focus of this challenge, section 5.4. And you pick it up, paragraph 35 on page 814. Lord Pannick submits that the assumptions which the valuer of Northern Rock shares is required to make, pursuant to section 5.4 of the Act, mean that the appellants will have been deprived of their shares for nothing or a derisory amount. In those circumstances, their rights under A1P1 will have been violated. It then sets out the common ground in paragraph 36. Paragraph 38, first paragraph, it's submitted that the shares were valuable assets. And at paragraph 39, what's said is that it was disproportionate for the state to take the shares and potentially collect a handsome profit down the line. And then the court turns to the principles under A1P1 that apply in this context. And these are set out under the heading above paragraph 43. And can I take you to paragraph 48? Where Lord Justice Law says the requirement of proportionality by no means implies that the erstwhile owner of property taken by the state must always be compensated at full value if a violation of A1P1 is to be avoided. Such a rule would frustrate, not fulfil, the search for a fair balance. There's then a quotation from the Holy Monasteries against Greece case. Compensation terms under the relevant legislation are material to the assessment of whether the contested measures respects the requisite fair balance, and notably whether it does not impose a disproportionate burden on the applicants. In this connection, the taking of property without payment of an amount reasonably related to its value will normally constitute disproportionate interference, and a total lack of compensation can be justified only in exceptional circumstances. And then there's an important sentence. A1P1 does not, however, guarantee a right to full compensation in all circumstances, since the legitimate objectives of public interest may call for less than reimbursement of the full market value. And that's the critical point, that there are some circumstances where there is a legitimate public purpose or legitimate objective of public interest, that justifies paying less than the full market value.
The obvious example is the one you gave us earlier, where the state confiscates the assets of someone who has engaged in serious crime. Presumably there you would deprive them of the entirety of the assets they have obtained from their criminal lifestyle.
Yes.
But can you give us an example, if you're able to, of where they should get some compensation, but because of public interest reasons, it's less than full compensation?
Yes. Well, the example is given by this court itself in the next
Right.
section. So if you turn over the page, there's a reference to James in the UK, which is where the sort of classic case that my lord has in mind, I think. James in the United Kingdom, 1986. The case concerned the terms on which tenants holding residential property under long leases were permitted, pursuant to the Leasehold Reform Act 1967, to enfranchise their property, that is, acquire the freehold interest in the land. So this is another example of private property changing hands, as it were, between private individuals. And it provided for some compensation because the landlords, an enfranchisement premium had to be paid in order to enfranchise. The landlord had no option but to accept that if it was calculated in the right way, but the landlord did receive some compensation. There was a challenge by the landlords in the European Court of Human Rights to the level of that compensation. And if you look at towards the bottom of that page, under the large indented paragraph, Lord Justice Lord says, secondly, the political context furnished a particular justification for the basis on which the price to the tenant for the freehold, notably less than market value, was fixed under the statute. The court said, like the Commission, the court observes that under the legal system of the contracting states, taking of property in the public interest without payment of compensation is treated as justifiable only in exceptional circumstances. As far as A1P1 is concerned, protection of the right to property would be largely illusionary and ineffective in the absence of any equivalent principle. The court then goes on at the next over the page, skipping a sentence. The court further accepts the Commission's conclusion as to the standard of compensation. The taking of property without an amount reasonably related to its value would normally constitute disproportionate interference. A1P1 does not, however, guarantee the right to full compensation in all circumstances. Legitimate objectives of public interest, such as pursued in measures of economic reform or measures designed to achieve greater social justice, may call for less than reimbursement of the full market value. And then, well, I won't read it out, but you'll see in paragraph 56, the court goes on to explain why the 67 Act was deliberately designed to be beneficial to tenants and designed so that the landlords would get less than the market value, and that was in part because it left out of account the construction value of the property, which was regarded as being, something that the tenant had contributed. And so there are factors like that which the Courts of Parliament's made a judgment about the fair distribution of resources and want to reallocate resources from landlords to tenants. And so by definition there's not going to be full market value paid because this whole measure is a measure of redistribution of wealth. There's then discussion of the Lithgow case, which I won't take you through, and the conclusion which this court draws in paragraphs 55 and 56 set out, in my submission, the ratio and the principle on which this court should proceed. In paragraph 55, the middle of that paragraph, it's stated, in the context of A1P1, the application of proportionality to a confiscation would ordinarily mean payment of an amount reasonably related to the value of the property taken. And then at 56, for the purpose of A1P1, this process takes concrete form as follows. The paradigm case of a reasonable relationship between compensation and the property's value arises, no doubt, where full market value is paid. In that case, the relationship between the two is one of identity. That, or something not far off, is likely to apply in what may be called microeconomic setting, where, for example, a single property is taken to achieve a specific and limited objective. Of course, that's where we are. In such a case, proportionality is likely to require market value or something close to it, and the margin of appreciation may offer little or no scope to justify the deprivation of property for less. But there will be other cases in which the objective of the deprivation is much broader. Emphasise the objective, perhaps as a matter of high politics. In such instances, the policy aim of the measure in question may be diminished or undermined or even contradicted by a requirement to pay full market value. And that's the question. The question is, well, what is the objective? And would it be diminished or contradicted if compensation is paid? The measure's intention may be to redistribute wealth, as in James in the UK, or to achieve necessary social reform, goals which are or may be perceived to be inconsistent with full compensation payable to the previous owner. In these cases, so these are the situations where full compensation is not payable, the margin of appreciation allows a flexible approach to the right protected by A1P1, which may give place to those aspects of the policy which overrode the case or payment of full value. So it's only where the government is pursuing a policy objective which would be undermined, diminished or contradicted if payment of full market value was provided, that there is a margin of appreciation for the government to decide, okay, well, how much should be afforded? And our simple submission is that there is nothing inconsistent with the policy of taking away or requiring us to divest up to a third party with providing compensation.
And do you submit, Mr. Hickman, that so far as the domestic courts are concerned, the system of binding precedent continues to apply under the Human Rights Act? Kay and Lambeth made that clear. So we, is it your submission that we don't have to be too concerned about the underlying Strasbourg case law? Section 2 of the Act tells us that we have to take that into account.
Yes.
But your submission, I think, is that this court has distilled the relevant principles on A1P1 in this passage. Do you say this is binding on us?
I certainly do, Mark.
But do you say that this establishes a principle that policy objectives, which may be taken into account in departing from full compensation, can only be policy objectives on a macro level, rather than policy objectives in relation to the particular single instance of the expropriation in question?
No, I don't say that, my lord. I mean, as I've given the example about, you take away somebody's proceeds of crime, that's not a macro.
Exactly so. So what do you say that the policy objective was of the deprivation order in this case?
The policy objective in this case was to prevent the possibility of the Russian state exerting leverage over the ultimate beneficial owners of my clients.
Or might be put more broadly, the risk was of espionage and cyber terrorism. Perhaps that's the objective, was to prevent that happening. Would that be a fair way of
putting it?
My lord,
I think there's a danger when one starts to define the objectives very broadly, that one can then start saying, oh well, margin of appreciation, there's possibly some inconsistency with providing compensation in that general context. One has to look very precisely at the reasons why this decision was taken and the reasons that have been given.
But I'm sorry to interrupt, but to stop at the stage of saying it was merely to prevent influence by the Russian state doesn't help very much. Influence by the Russian state in order to achieve what?
Well, my lord, the point is that you could achieve the goal. You could give compensation to my clients, and the goal would still be 100% achieved. It's not inconsistent at all. You couldn't do that in James. You couldn't achieve Parliament's objective and at the same time give more money to the landlords, because it would diminish the achievement of Parliament's objective. You couldn't compensate somebody who's got the proceeds of crime to any extent without diminishing the objective. But in this case, the objective can be 100% fulfilled by providing us with compensation.
Well, I wonder whether you're talking about achieving the objective in the same sense. If some piece of property is intended to be used for crime and it is confiscated, I think you're accepting in those cases there would be a policy objective, namely the prevention of crime, which might justify not compensating.
Well, my lord, if that was an innocent individual, if an individual happens to have, the government came along and said, terribly sorry, but we'd like to have your house because we know about some bad people who we think will take over your house and use it for bad purposes. The government would have to pay compensation.
Yep. But conversely, if it was the criminal himself, then not so. So it's a fact-sensitive inquiry as to what the reason is in relation to the particular policy objective in question.
Well, my lord, there's no
right?
policy objective advanced. The pleading of the Secretary of State does not set out any policy.
No, I understand that point, and we've come back full circle to the point I was testing earlier. Thank you.
Can I just close off?
If the objective of protecting national security can only be fulfilled if it comes with what may be a heavy price tag, is that relevant to the extent of the margin of appreciation?
Oh, my lord, that's no part of the case against me. That's not. There's no evidence of that. There's no pleaded case to that effect. My submission, that's not a relevant point. But it's a very slippery slope if you start going down that kind of situation, because the government can always say, oh well, this would be expensive to do this. It would be. We really would like to have a railway that runs directly through all of these people's property, but if it's going to be expensive, we might not do it. So, I mean, if that type of reasoning opens everything up and effectively undermines A1P1 entirely. Just to close off the Northern Rock case, you can see the way the principle is applied. I'm not going to go through it in detail, but if you look in paragraph 66, in the second half of that paragraph, the court is very clear to identify that the reason why those assumptions that were built into the compensation assessment were appropriate was precisely because the government was not intervening to protect Northern Rock, it was intervening to protect the rest of the society. So it would have been inconsistent and would have given a windfall to the shareholders, as it were, if their compensation had been calculated on the basis, on the assumption that such assistance would be provided. And then finally, at the end of paragraph 77, again, Lord Justice Laws, as I've said, the purpose of the assumptions was to put the shareholders in the position they would have occupied vis-à-vis the value of shares had no lender of last resort support being provided. That objective was achieved. Once the whole context in which it was evolved is understood, it can by no means be characterised as manifestly without reasonable foundation. So in my submission, sets out the principles and indicates what it would be necessary to justify the absence of compensation in this case. So,
can I just ask you about that last formulation? That's very familiar language from A1P1 cases.
Yes.
On your submission, is that the test that we must apply? Whether what's happened is manifestly without reasonable foundation?
No, that's not. That's no. The principle you have to apply is 55, 56.
Right.
That was the way it was, as it were, put by Lord Panic in that case. If you want further authority on that, my lord, there's the Welsh asbestos case in the Supreme Court, where the Supreme Court finds that when you're looking at proportionality under A1P1, as opposed to legitimate, whether there's a legitimate aim, you don't apply the manifestly without reasonable foundation test. I can provide that authority to you. So that is a yes.
I think it would be helpful if you could send that through to us.
I certainly can. That's really just aping the way the argument was put.
Yeah.
So grounds of appeal, I've set the principles out, I've explained, I hope, how we say they apply to our case. So I can take relatively quickly what we say are the errors in the judge's reasoning. And if you turn the judgment back up, tab 8, the core bundle. The first point is that the judge did not make a determination on our submission that there was a deprivation of possessions in this case. And the submission is recorded in the judgment at paragraph 191, and at 193 the judge says it was not necessary to decide the point because the central issue is proportionality. But we say that was the wrong starting point, because as I've shown you, the authorities do take a different approach where there's a deprivation. Of course there are cases where it doesn't make a difference, but it is the correct starting point, and when you're talking about compensation as opposed to proportionality generally, the principle is different. And I started off by showing you Mott and the quotation from Lord Justice Newburger in that case. Normally, compensation is required where there's a deprivation, and then the circumstances in which it's not provided are set out by this court in the Northern Rock case. So it was an error not to decide that point. The submission that was made below was primarily focused on the fact that this was a divestment to a third party and not to the state. Now, we say that is an erroneous submission. It's repeated at various places in my learned friend's skeleton arguments. And again, we say there's Court of Appeal authority on this point. It's the other document I've handed up to you. It's the East Side Cheese case. Now, I accept that this is opita, but it's nonetheless an important statement of principle. The case was mainly decided under EU law, but towards the end of the judgment, there's a discussion of Article 1, Protocol 1. It was about restrictions on cheese because of an outbreak of E. coli. If you turn to paragraph 56, this court says, "We are doubtful whether the present case is one in which the effect of the order was to deprive them of their possessions. There was no transfer of ownership from them to the state or any other party." There's a clear reference there to the fact that a deprivation could be to another party. And then if you look down at paragraph 57 below, after setting out the Strasbourg principles, such a rule is readily understandable where the state is itself assuming ownership of property belonging to another, or where property is being transferred from one citizen to another. And then...
Oh, sorry, just while you're there, save me having to go back to it, could I invite you just to read 58 and 60 very quickly?
Can I ask you to turn to James and the UK very quickly, which is in the Authorities Bundle 2 at tab 20. And I just highlight a few parts of that. I've already essentially told you what it's about, explained that this was legislation that permitted tenants to obtain compulsory transfer of ownership from a landlord. And if you look at paragraph 10,
It's in my volume 3.
page 974 of the Authorities Bundle. At the end of paragraph 10, the applicants as trustees have been deprived of their ownership of a number of properties in this estate through the exercise by the occupants of their rights of acquisition goes on to explain how the legislation works. And if you turn forward to paragraph 38, it's clear that the court is treating it as a deprivation. And if you look at 68, just to point out, make good the point I made about the way Strasbourg uses the word expropriation, 4 lines up from the bottom. Expropriation legislation of wide sweep, in particular, implements a programme of social and economic reform, is hardly capable of doing entire justice in the diverse circumstances of a very large number of individuals. And then 70, again, is the second sentence of A1P1, the deprivation.
Sorry, which paragraph?
70.
I'm not seeing that sentence.
To sum up each of the requirements of the second sentence.
Yeah. Got it, yeah.
Therefore satisfied. There's also a case A against Sweden, which is at tab 16 of the bundle, which again was a transfer from one neighbour to another neighbour, and this is treated as a deprivation of property. And thirdly, Osmanian and Armenia, which we've looked at already, and I've already shown you that that case was a case of a transfer or a process which allowed a private copper mining company to obtain the applicant's land. In identifying what is a deprivation, the focus of the European Court of Human Rights is very much on whether there's a conclusive transfer of ownership. C, for example, and Donsky against Macedonia, which is at tab 15. And I'll just show you the one paragraph, which is paragraph 30, which sets out the principle. In the instance case, the court notes the confiscation of an applicant's car was a permanent measure which entailed a conclusive transfer of ownership. The court therefore considers the measure amounts to a deprivation. Now, there are circumstances which are referred to in the case of de facto deprivation, where there's not a conclusive transfer of ownership, but nonetheless, because of the extent of the restrictions, it's treated as a deprivation. But here we obviously don't need to rely on that because we're squarely within this principle. The reliance below was placed on the judgment of Mr. Justice Green, and then was in the British American Tobacco case. Can I just briefly show you that? It's in the First Authorities bundle. It's frankly most of the First Authorities bundle. Tab 7. Fortunately, most of it's not relevant to us. And at page 527, His Lordship set out, summarised the principle, and
I think it goes into the second volume.
I'm sorry, madam.
I think it goes into my second volume.
Oh, does it?
You're at page 527.
I'm at 527.
Yes, thank you. Paragraph
783.
Yeah, got it.
So the first point to note is that Mr. Justice Green, in this paragraph, is just saying he's setting out a summary. It's nothing more than a summary. And at the third indent, Roman 3, he says the two most important criteria for differentiating between expropriation and control of use are A, whether the measure pursues a legitimate objective, and B, whether title transfers to the state. And emphasis was placed on that below. But in my submission, it's reading far too much into this to suggest this is any authority at all against the authorities I've referred you to, including Eastside Cheese in this court, because this was a case about regulations that imposed restrictions on tobacco advertising, and in particular, the use of trademarks. And the question was the restriction on the use of trademarks so severe that it amounted to de facto deprivation? And the court said no, because the trademarks were still valuable, they could still be used, they could be used in other countries, and so on and so forth. There was no issue in the case about transfer to a third party, so it wasn't something the judge was focused on. And then, in any event, if you look at page 528, at paragraph 785, the judge is setting out his reasons why it's not an expropriation of property. And he says, first, the trademarks remain unequivocally the property of the claimants. The state has not expropriated or taken away the rights for itself or to be handed to some third party. So, the case went to the Court of Appeal, and that's in the next tab. I'll just show you that very briefly. This court again went through the principles concerned A1, P1 at paragraph 93 and onwards. And this court at paragraph 93 described it as a critical distinction between deprivation and control of use. That goes to the point I made about the judge not having decided this. And then the principles are set out. Now, there's no consideration in these paragraphs of this point about transfer to a third party, because as I say, it wasn't an issue in the case. But I note that the court does cite the Eastside Cheese case, and that is, I think it's over the page at paragraph 98. And I'd just like to draw your attention, because some reliance is placed on these authorities by my learned friend, to what this court said in paragraph 97. And this is in relation to the situations where there is some prohibition or restriction on goods, which are then used in breach of those restrictions or prohibitions, and then they're taken as a way of enforcing the law. And the court said in those type of cases, they'll be treated as a control on use.
Yes.
So if you look at the German gold case, which is halfway down paragraph 97, the complainant sold gold coins subject to a retention of title clause. Before the title had passed to the buyers, they attempted to smuggle the coins into the UK. They were caught and the coins were forfeited. The sellers, who were wholly innocent, complained about the loss of the coins, which were still their property. The court held that the prohibition on the importation of coins to the UK was control of use, since the forfeiture was a measure for the enforcement of this aspect of control of use. So it too was a control of use rather than a deprivation. Thus, even though the forfeiture of the coins did involve deprivation, as far as the sellers were concerned, it still felt to be treated as a control on use. Now, of course, we're not within that category of case, not least because the Act wasn't even in effect at the time we purchased up. So we do say the judge was wrong in not finding that it was a deprivation, and it clearly was a deprivation. The Secretary of State, in skeleton argument, my learned friend, makes other arguments and says that because the final order set out a process by which the sale had to be effected, that somehow changes the character of the exercise fundamentally, so that it was not a deprivation but a control of use. In my submission, there's simply no basis for that. It is perfectly clear that the final order required divestment, which is a deprivation. The fact that there is a process that has to be gone through doesn't change the fundamental character or nature of the order. For instance, if one is expropriating property to be used for train line, the fact that there is a process to be gone through which involves assessing the level of compensation doesn't in any sense change it from deprivation to a control of use. And indeed, a similar sort of process to the one I've just described was gone through, as we saw briefly, in the Osmanian case, where the copper miner had to bring a claim in the court, and there was a whole process for assessing compensation and for obtaining title and so forth, but it was still treated as a deprivation. The respondent says in the skeleton argument that my clients were at liberty to decide whether to sell or wind down or otherwise divest. This is in the skeleton argument. It's not clear what otherwise divest means. As between sale or abandoning the company, as you've seen, the Secretary of State's position during the sale process was that we needed to go through with that process, not least so that we could recover something to mitigate the losses that we would otherwise suffer. In my submission, there's nothing in those points. Similarly, the argument that we had a choice over who to sell to is irrelevant. Ultimately, we had to sell, and it was under compulsion of law, and the Secretary of State maintained control and had a veto over who we sold to. So that's the first point. Very briefly then, take together our grounds 2A, B and C, all of which relate to paragraph 225 of the Secretary of the judgment below. So I'm just asking you to turn up 225. The judge stated in this paragraph that A1P1 does not require compensation, Paragraph 223, just to start with the relevant part, the judge says that A1P1 does not require compensation, must always be paid in cases of deprivation. And we accept that, because I took you to the Northern Rock case, which sets out the principles. But with respect, the judge didn't follow the principle in the Northern Rock case. Instead, she says that because compensation doesn't always have to be paid, it's a fact-sensitive balancing exercise, question of fair balance. And then at 225, she engages in the exercise of judging the fair balance herself. And she says, first of all, the interests of national security must prevail over the claimant's financial interests. We say that this is a false dichotomy, because compensation and national security are not in conflict in this case, as I've explained. The Secretary of State has not advanced any policy rationale in the pleaded case or in evidence which is inconsistent with compensating my clients in full. The judge goes on to say it's implausible to suppose that the loss of UP destroyed the livelihood of anyone in the L1 group, or that the group cannot reinvest the proceeds of sale into profitable investments. Now, it was never our case that, it isn't my case today, that anyone's livelihoods are going to be destroyed, nor that what little was recovered can't be reinvested. But neither of those are relevant considerations.
Do you ask us to keep in mind the paradigm case where subject to anything Sir James says to us, I think everyone in this country would accept deserves, let's call it fair compensation, because I know there's some issue about what the meaning of full is. Right? So the paradigm case I have in mind is, I've got a house which is right where a new motorway is going to go through. So the fact that my livelihood is not going to be affected, and the fact that I can invest the proceeds of sale in something else, you would say, is neither here nor there in that paradigm case. You can't give me £100 compensation when my house is worth £100,000.
Yeah, exactly. And that's why the example we give in the skeleton is a case of property, because in some respects, when you've got a physical property and talking about that being taken away, somehow the principle stands clearer than when it's a company for some reason. But it's still an asset, valuable asset that's being taken away.
And it could be different, as you say. Cases like James illustrate the point that if the whole point of the underlying social exercise is to redistribute wealth from me to others who are more deserving in society, well then it may well be that I only get £100.
Yes.
But that's because there's a public policy imperative justifying the reduction in compensation from what would otherwise be fair value compensation. But we'll hear submissions to the contrary, no doubt. But you say that here there is no such public policy advanced so far as the level of compensation is concerned, as opposed to the underlying reason for making the final order.
Exactly. And if there is such a sort of public policy rationale for redistributing wealth, it has to be done, it has to be a clear, democratically accountable decision to do that. But here there is nothing. The compensation doesn't appear to have been even considered when the decision was taken. Certainly none of the documents we've got refer to that as a possibility. The judge goes on to say, in the same paragraph, large-scale investors cannot be surprised that they may lose money on investments that threaten national security. Well, a number of responses to this. First of all, there's no principle under A1P1 that investments that may be regarded by the government as contrary to national security are somehow inherently vulnerable. That would introduce a major qualification into A1P1. And it's not obvious why there should be, as a matter of principle, because it's just as much in the national interest that property is taken to build a road or to put to some other use as it is to take property to protect possible future national security risk. Furthermore, as I've said, the judge has not taken into account or had any regard to the fact that this was retrospective legislation, and that yes, there is a mechanism where people perceive a risk to national security under the Act to obtain certainty on that, and they can be expected to go through that process, but that wasn't an option available to us, and we do say that was a material consideration which wasn't given effect, which wasn't taken into account.
I think Sir James says in his skeleton argument that this wasn't run below.
Yeah, well, that's wrong. Can I just show you very quickly, Corbund, page 247. Just the easiest reference. It's the skeleton argument, our skeleton argument below.
Sorry, which page?
247 of the Corbund. So this is in the section dealing with A1P1. And you can see that the reliance on the retrospective nature is set out at paragraph 163, points 1 and 2. There's also reliance in the same paragraph on the fact that my clients are large-scale investors who are sophisticated. Well, with respect, there's no principle that the European Convention on Human Rights applies any less to large-scale investors, small-scale investors, and so forth. And there is a risk that if one starts taking into account those sorts of factors, it essentially becomes a process of redistribution, saying, well, these people have got broad shoulders, they can pay for it, which isn't the principled approach that Article 1, Protocol 1 requires, unless, of course, Parliament is redistributing wealth through some social policy agenda.
I mean, that no doubt might have been said about, for example, people who had invested in very large companies which ran utilities, for example, in the past and were nationalised. Obviously, we'll hear Sir James if there is authority which supports the principle that being a large-scale and sophisticated investor means that you're entitled to less compensation under A1P1. I don't know what the answer is, but you say there is no such principle.
Paragraph 227 of the judgment.
Yes.
Oh, sorry, before I do. Paragraph 226 of the judgment, the judge says that there was a point taken in reply that the state is bound to pay compensation unless by doing so the purpose of the measure that requires deprivation of property would be undermined. Along the lines of points I've made to you about the Northern Rock case. Well, with respect, this paragraph is a misrecollection of what occurred, and we've got the transcript. It's in the bundle and you can read it. But the judge did ask me in reply to take it to a point in the skeleton, but it was in relation to a different point altogether. So I'm afraid it's just a misrecollection there. And we put in the bundle the relevant passage and invite the court to read it. But you can see that the key point is that this was a point that we were running all along, and you can see it's referred to in paragraph 214 on the preceding page. Mr. Luxembourg, who brilliantly took this point in the initial submissions, is recorded as having submitted that the Secretary of State had not said that paying compensation would itself cause a national security risk or undermine the statutory purpose of protecting national security, nor was it a social policy. It's the same point.
Well, again, it's subject to anything that Sir James may say to us in due course. Speaking for myself, I tend to take the view that once a case has reached the Court of Appeal, it's our duty to get the law right. And we're not that interested. Sometimes we have to be interested in the procedural archaeology, as Lord Bingham once referred to it, but it's often not really a good use of time.
Well, that's why I don't want to take you through the transcript, but you've got the transcript there.
Yes, I'm grateful.
If you're so minded. I'm nearly done.
Yes.
My lord. Ground 2B of our grounds, paragraph 227. The judge says in that paragraph that she's not been referred to authority that compensation is assessed by what the claimants assess their loss to be, and not by what the market is willing to pay. But that was never the case. The case was never, and it's not my case before this court, importantly, that compensation has to be what we assess it to be.
Yeah, that's really why I asked that question I did earlier, because I may be wrong, but I get a flavour that the proposition seems to place emphasis on the words as assessed by the claimants.
Yes.
But that's why I asked you to clarify. That's not your submission, as I understand it. What your submission is that even if it were assessed by an independent expert, that's what you would be asking for.
It's not, my lord. It's not even my submission that even if it was.
Yeah.
It's my submission that it should be assessed by independent. That's positively what we say should have happened, and given that it didn't happen, it's what the order we asked for, that this court order that it be remitted to a judge in the absence of anyone under the final order appointed to do it, to work out whether we ought to have further compensation, because we haven't, or how much compensation, I should say, we should be given. My Lord, just in terms of the principle of fair market value, we've quoted a couple of things in the skeleton argument. There's the International Glossary of Business Valuation Terms, which you have, page 1330 of the Authorities Bundle, which defines market value. There's also an extract from the case of Richards and Speechley Bircham, which is in tab 6. Perhaps I'll just very quickly show you that. Tab 6 of the First Authorities Bundle. And you don't have the whole case, it's only one paragraph, paragraph 196, that we have cited. And it just sets out that in this case it was an agreement of experts. Fair market value is an appropriate standard valuation. Fair market value can be defined as the price at which an asset will change hands between a hypothetical willing and able buyer and a hypothetical willing and able seller, acting at arm's length in an open and unrestricted market where neither is under compulsion to buy or sell. And we say that's fundamental, and we're not saying it just has to be what we value the asset at. Our ground 2F, procedural mechanisms. You've seen, my Lord, that we pleaded that there should have been a mechanism. We've mentioned it several times. Let's just see the way the judge deals with this. At 224 of the judgment, well, 221 is the principle. So she cites the Listins case at 221. In order for deprivation to meet the requirements of A1P1, there must be a procedure for ensuring an overall assessment of the consequences of deprivation, including the award of compensation in line with the value of the expropriated property. And then she dismisses this part of our case, paragraph 224, the third sentence, where she says, I see no dearth of procedural mechanisms for the overall assessment of either the award of financial assistance or its amount. That's the only place where she deals with it. And doesn't it explain what these procedural mechanisms are? With respect, there weren't any, because the only mechanism is the possibility of a claim such as this claim under the Human Rights Act, because the final order didn't make any provision beyond the sale. Once the sale price is known, there's no further provision by which its adequacy as compensation can be assessed. Finally, ground G, the judge's reliance on section 30. I mean, I've essentially already dealt with this point. The request for assistance under section 30 was a request that occurred before the sale. It was not a request that was made on the same basis as this claim, and therefore it can't possibly be, as it were, some kind of substitute for this claim. The relevance of it is simply that had the Secretary of State agreed to provide some assistance during the course of the sale process, that would have reduced our loss. But since the Secretary of State didn't do so, there's no element of compensation that needs to be cancelled off or taken into account. And that's the sum total of it. I mean, the point, failure to provide the compensation is fully set out in our amended pleading in this case. So, my Lord, for those reasons, we submit that the appeal should be allowed and the case remitted for us to pursue our damages claim in either the administrative court or, if more convenient, in the King's Bench Division.
Check if there are any other questions. Thank you very much, Mr. Hickman. So, James, can I just inquire mildly how long you think you'll need?
My lord, it might be an hour and a half, thereabouts.
Yeah,
No,
that-
no, we're well within the time.
Yeah, well,
so
certainly you have plenty of time for a reply.
Yeah.
Very good. We look forward to hearing you at 2 o'clock.
thank you.
All right, table.